Hitbullseye, and in today's topic, we are going to discuss the first 15 days of February, all the important judgments, all the important developments of law in the first half, basically, of February month. So, the first most important judgment that we have already covered in the last episode is the judgment on living wills and passive euthanasia. That is the new guidelines on living wills in common cause versus the Union of India. Proceeding forward, the other more important judgments, like the other important judgments of the first 15 days, are the first most important judgment or a development we can say in the judgment is that of Joseph Shine versus Union of India. So basically, Joseph Shine versus Union of India is a 2018 judgment. In this judgment, the Supreme Court, in its three judges bench, decriminalized the offense of adultery. Basically, it held that Section 497 of IPC was punishing adultery, and funnily enough, in this case, only the paramour of the wife was punished in this regard. So therefore, it was considered to be an offence in which only men could be convicted. So it could have been said that it was an offence which was giving undue advantage to women. But at the same time, the court in this case in 2018 went into the lower levels of it, and in order to basically understand what are the principles of adultery, and what are the principles on which this person is punished. And it found out that the principles laid in deep down in the patriarchal system that the government, the legislation before followed, and which was of the mentality that the wife is the chattel of the husband, or the wife is the property of the husband, and therefore if she cheats with another person, or if another person takes the property of the husband, then it is considered to be an offense against the husband. But the same cannot be said so in the case of the wife. If another woman is cheating on if the husband is cheating on the wife with another woman, similarly, she won't have been punishable. So, in this regard, the Supreme Court back in 2018 stated that this is discriminatory against women, as the principles under it treat the women as chattel or the property of men, and therefore it decriminalized this offense. It could still be said to be grounds for divorce, which was gender neutral again, but at the same time, it wasn't an offense punishable by law anymore. However, the central government recently filed an application in this regard to the Supreme Court, asking the Supreme Court to clarify whether this thing is also going to the Joseph Shine versus Union of India judgment is also going to apply on the armed forces as well or not. In this regard, there was a five-judge bench that was constituted. The five-judge bench consisted of Justices K.M. Joseph, Justice Ajay Rastogi, Anirudh Bose, Rishikesh Roy, and Justice C.T. Ravi Kumaran. And in this case, the bench finally came to the conclusion that it is actually uh, uh, 497 will not be read standalone as a standalone provision in the case of armed forces. Basically, it took into notice Article 33 of the Constitution of India, which states that the Parliament by law can make special laws for the armed forces, that is, the Indian Army, Navy, and the Air Forces. The armed forces is on a different footing in this regard. The Supreme Court stated that considering two sections, that is, Section 45 and 63 of the Armed Forces Act, it stated that if we consider these two sections, then these two sections punish the uh, the conduct which is out of discipline, or indisciplinary conduct of the army men, or the officers in the army. In Section 45, it states that if there is any conduct which is unbecoming conduct of a servant, of an armed forces servant, then it shall be punishable or it shall be taken cognizance by the court martial. And under section 63 of the Armed Forces Act, it states that a person can be punishable for all the acts which will be prejudicial to the good conduct of an army officer and which will be again unbecoming of an army officer, up to a punishment for a punishment for up to 7 years of imprisonment. So therefore, they stated that the intention for creating the intention for not applying Joseph Shine versus Union of India, or the intention of not forces only, whereas it is decriminalized in all the other cases on to civilians, the intention behind this is in order to have some discipline or in order to retain some discipline in the armed forces. So, in this regard, let us read what the Supreme Court has said. The judgment of this court was concerned only with the validity of 497 and section 198 CRPC. In this case, the current court had no occasion to consider the effect of the provisions of Armed Forces Acts. As we notice, it is not as if this court approved of adultery. This court had founded adultery to be a modern problem, which should not be essentially punishable in the by sending a person in jail as such. This court also held that it will continue to be ground for dissolution of marriage, again a civil problem. In view of the fact that the scheme of the dissolution of marriage, the scheme of the acts in the context of Article 33 did not fall under the consideration, sorry, did not fall under the consideration before this court. We must observe and clarify that the judgment of this court will not at all be connected with the effect of the provisions of the Armed Forces Acts. Meaning to say that even though Joseph Shine versus Union of India has decriminalized adultery in for the civilians, it does not mean that it has decriminalized adultery in the case of the armed forces in court martials. Coming on to the next judgment, the Supreme Court stated that being short of funds to pay court fees is not a sufficient cause to delay to file an appeal. In Ajay Dabra versus Pyare Ram, Justices P.S. Narsimha versus Sudhanshu Dhulia, they stated that essentially when we use the Limitation Act 1963 in order to ascertain how much time is to be given to a person to file a particular suit, to file a particular application, or to file a particular appeal or any thing as such. So basically, how much time is given to an applicant or a person who is coming with a certain complaint. And however, in the case of appeals and applications, there is a provision for condonation of delay as well, but that condonation of delay can only be taken by a person in case if he has some genuine reason for condonation of delay. Now, this genuine reason could be that he is sick, or he was unable to come to the court, or he went to maybe the court of the wrong jurisdiction, and he filed or pursued the case in good faith. But however, one reason that cannot be considered valid in this regard is that the person was poor, or the person had insufficient funds as such. So in this case, the Supreme Court stated that a person cannot get his get his delay condoned on the basis of poverty. In case he was poor, actually, in this particular case, the person or the applicant was 254 days behind schedule, and there is usually a time of 30 to 90 days depending on the court in which he's thinking of filing the appeal, and which is given generally to file an appeal from the date of the order. However, in this case, the person was more than 200 days sorry. However, in this case, the person was more than 200 days delayed. And in this case, the court stated that in case he was able to not pay the fees, he could have asked for section 149 provision of CPC to be applied to him. And 149 of CPC basically states that in case a person is not able to pay some court fees, then the court can also allow on its discretion to have the person pay the court fees at a later stage and first commence with the proceedings at least. So, therefore, the Supreme Court held that poverty is no reason to condone the delay of an appeal. The next case is the Satyendra Kumar Antal versus CBI, and actually there are three cases in which that have happened recently, in which the Supreme Court has on and on stated that certain provisions should be applied, certain provisions in their landmark judgments in the previous years, especially two judgments, which are Siddharth versus the state of Uttar Pradesh and Satyendra Kumar Antal versus the CBI. But this is a case of 2021 and this is a case of 2020. Both are important judgments, so much so that the Supreme Court has also stated that while teaching the provisions of arrests and bail in the judicial academies, these should also be taught thoroughly to the new judicial officers as well. The cases are primarily as such in Siddharth versus the state of UP. A bench of Sanjay Kishan Kaul and Rishikesh Roy had stated that at the time of making a charge sheet, that is, at the time the investigating officer is already done with the investigating process and he is ready to file a charge sheet against the accused. So, as per going by the wordings of section 170, sometimes only to stick very much by the book, the investigating officer, what he does is he makes an arrest of the person even if that arrest is not required. And this arrest is essentially a formality because the arrest and the bail provisions have been mentioned under section 170 of Code of Criminal Procedure. So what he will do at the time throughout the investigation, a person would be out on bail or would have probably not even be arrested in that regard because his arrest would have not been required also. But at the time when finally the investigating officer is filing the charge sheet, what he would do is he would make a formal or what you can say a cursory arrest, and then he is going to let that person go on bail also. So this is a very non-essential requirement. It is a very non-essential conditions, and it was only meant for people who were already arrested at the time of investigation per se. So this was not intended to be for people who were not arrested. So in that case, the Supreme Court said that in under Siddharth versus Union of India, Siddharth versus Uttar Pradesh, I'm sorry, the Supreme Court stated that such an arrest is not required, firstly. Secondly, in Satyendra Kumar Antal versus the State Union of India, the Supreme Court has stated that bail is not a mechanical process and it cannot be treated as such. So, proper regard has to be had with, first of all, Section 41A of CRPC in making an arrest, and all the judgments, all the developments which have been brought in by should think about introducing a bail act which defines when and how and in what. In the next case is very short case but a very important case as such. Arun Motiwal versus Union of India. In this case, the Supreme Court has clarified that surrogate mothers cannot provide their own gametes under the Surrogacy Act. So there was a PIL that was filed which aimed at banning done by somebody who's near or close to the intended couple. In this case, the very meaning of surrogacy is that that the womb of the woman who is the surrogate is used for 9 months and nothing more. So essentially, she cannot provide her own gametes. Gametes meaning to say ova or eggs. So she cannot provide her own gametes for the purpose of surrogacy. Otherwise, it will not be called surrogacy in the first place. and the child to be born through surrogacy must be genetically related to the intending couple. The eggs, the basically the eggs and the sperm should be of the intended couple and not the surrogate mother. So, in our last case that we are going to discuss today, Sunita Pandey versus the state of UP. This is a case, this is actually not a judgment by the Supreme Court, this is a judgment by the Allahabad High Court, but very important as such. So, in this particular case, the Allahabad High Court stated that a woman can't commit rape but can be guilty of gang rape if she facilitates rape by a group of persons. So first of all, if generally we consider what are offences against women, there is a list of offences that includes sexual harassment, voyeurism, stalking, etc. And also it includes the more aggravated form of these offences are rape and certain other forms of rape, which are such as gang rape or rape by a person in authority, etc. So essentially, if we talk about in general the whole category of these offences, these are gender specific offences and cannot be done by a woman. They can only be done by a man, and the victim is always a woman. But sometimes in the case of gang rape is specific. If we talk about the facts of this case, in this case, there was a 15-year-old girl who was enticed or who was taken. Essentially, she was kidnapped by another woman who was an adult, and she was taken to some place and gang raped by a set of persons. Now, in this case, when the victim came back and when the victim named this girl, this woman, that she facilitated the gang rape, the police did not file the charge sheet against the perpetrator of the crime on the basis that she was a woman and gang rape cannot be facilitated by a woman. So, in this case, the Allahabad High Court differed in its view and stated that it is agreed that a woman cannot rape, but at the same time, the woman can facilitate the rape. If we go by the definition of section 376D, that is the definition of gang rape, it states that when a woman is raped by one or more persons. So the word here that is used is essentially persons and not men. So in this case, we have to take the person, the word person in the as per the meaning which is given to it by Section 11 of Indian Penal Code, which includes man and a woman both. So therefore, the Allahabad High Court said that the woman was also guilty of having the common intention to gang rape the 15-year-old girl, and therefore, and later also harboring the other people, harboring the offenders as well. So therefore, even though the other forms of crimes against women can only be perpetrated by men, this is a particular